All right, welcome back, everybody, for the final panel of the day. We're covering private enforcement of the DMA. Now, Brussels is not the capital of private enforcement. We don't know yet which European city will claim that title, but this is very much, of course, a city of public enforcement. So what is private enforcement? For those of you who don't know, this is where you go to a national court and you say a regulation or a law has been infringed. I have suffered damages from that, and the company who has caused those damages should stop doing what they're doing, maybe pay me back my damages, or it should be ordered to change its conduct. Now, if I explain that to you and you think about what the DMA is and intends to do, you can immediately see that that can be both a big opportunity for some stakeholders, but also a potentially a big headache, not only for gatekeepers, but also, of course, for the key enforcer of the DMA, the European Commission, because how would they deal with potentially inconsistent outcomes coming out of national courts? So I think there is a real question at the moment, and we're very much at the early stages of private enforcement of the DMA, which obviously lags behind public enforcement, around whether this is going to be a correction mechanism, a very welcome correction mechanism, where people with reasonable cases can get reasonable outcomes, and everybody's ultimately better off, or whether this is really going to end up being quite a disruptor. And I think we've got a great panel to discuss that or those topics with today. So I will quickly introduce everybody and then we'll kick off the discussion. So starting with Helen. Helen Gornel is a partner at De Brouw in Amsterdam. De Brouw is an international law firm based in Amsterdam primarily. And a key player, I would say, in digital markets. We have Jörn Ashmond, who is a director at Burford Capital. Burford Capital is a litigation funder. We will come on to the role of litigation funders during this panel. I won't spoil that at this stage. Joe Perkins, he is the only economist with us this entire day today, which means he either did an exclusive deal with us, or maybe it's more actually a sign of the fact that economics have perhaps played a big role in what has driven the adoption of the DMA, but not so much yet in the enforcement of the DMA, and we'll come on to that as well. And finally, my colleague since about a month, Thomas Hoppner, who is a partner at Jared & Partners in Berlin, and someone who has been involved in many digital cases, mainly on the complainant side or the plaintiff side, and will share his perspectives with us from that side today. So, you know, with that introduction and this idea of this being very much a place for public enforcement, I was wondering if we could start with just explaining how cases will make their way to the national courts of your two jurisdictions, Helen and Thomas, and maybe starting with Helen.
Sure. Can everyone hear me? Is it working? Yep, good. So yeah, I'm based in Amsterdam. So to a certain extent, this is the position in the Netherlands. That said, we are like many jurisdictions in the EU, I think with the exception of Germany, and Thomas will speak to that we have not embedded the DMA into national law in terms of saying, hey, under the DMA, you can definitely start claiming damages in the Netherlands. So what does that mean? Like many other jurisdictions, it simply means that you can bring it under standard civil liability rules. Now, maybe just to take a step back, which is a funny thing to do with a forward-looking regulation, but nonetheless, let's take a step back from it ending up already in the Netherlands. When the DMA was put together, there was obviously a discussion at that point. How do we feel about the idea that we will take a piece of legislation and allow people to enforce it nationally? Now, we already know that the NCA's lost out in being able to enforce the DMA. But actually, when the DMA was put together, it was decided that there would be this very important role for national courts, or at least let's see how important it is, but nonetheless there would be some ability. It's obviously a regulation, it has direct effect. That means that you can bring things in national courts. That said, it was very clear from the beginning that really the EC was going to be the true gatekeeper. I shouldn't use that term. But they would be the main body to oversee the DMA, and therefore the question is, what's the role for anyone else? Now, under Article 39 of the DMA, very clearly states that you can bring the DMA nationally, but with very clear safeguards. And we can go into some of those later, but obviously it was pretty critical that the DMA would have a clear role in the proceedings at national level and having a say in written pleadings, but also potentially orally when those things come to court. So there was no sense that courts were going to be allowed to make up rules relating to the DMA without the Commission being involved. And most importantly, under 39.5, we have the provision that says, hey, not only that, national courts, but if the European Commission is actually looking at a case, then you need to consider staying your proceedings while the Commission actually decides what it thinks about the case. And then at that point, once the Commission has made its judgments, then potentially you can continue that litigation at national level. So very, very critical that this is not something standalone. And in that way, the European institutions try to make sure that there's, limited fragmentation of the outcomes. But clearly, that is still a really big risk. Also, under the DMA Article 42, we see that reference is made to representative actions. So the Representative Actions Directive is specifically applicable. That means that where there are class actions possible at national level, you can definitely use those to bring class actions with the DMA in mind. So that's kind of either as an individual, a competitor, a customer, or as a bunch of consumers, you can bring those claims through the national courts. In the Netherlands, generally the district courts, although interestingly we have seen things actually even start in small claims courts in the Netherlands, but generally the district courts. And then the next point is, well, what are people actually going to be turning up to do? Are they going to be claiming damages? And we can speak to the sort of follow-on nature of this in a second. But often they may actually be wanting something else. It's forward-looking. Maybe they actually want an injunction to stop future behaviour rather than backward-looking. What is the loss that I've suffered? And also maybe periodic penalty payments to say we want the gatekeeper to pay until we see that their conduct is in line with those rules. So yes, you can bring them, certainly, in member states. There may be slightly different avenues to bring it, but in the Netherlands it's possible either as a sort of mass claim or individual companies bringing those claims.
Thanks. And Thomas, you want to give the German perspective? Because in Germany there has indeed been legislation on the point, right?
Yes, that's correct. Firstly, I agree with what said, also with the direct applicability. So even without such national implementation, you can go to court because as a regulation, these obligations are directly binding. Now, Germany was the first country that decided that they want to have specific rules to make sure that private enforcement is possible and in line with the existing regime. Basically, they have expanded the current regime for the private enforcement of competition law, Article 101, 102, to the realm of the DMA, which has some positive side effects. It's not just saying you can now go to court and ask for a cease and desist or for damages, but also some ancillary rules are applicable that make it more easy for a plaintiff, such as access to disclosure, such as making sure there is jurisdiction, rules on limitation that are more favorable. So the realm of the damages directive has effectively been expanded through this German law to the Digital Markets Act, which in a way closes a loophole that the DMA has left because it it assumes private enforcement, but it has no substantial laws on it.
Yeah. And have there been any cases yet in Germany?
We're still at an early stage. I think most are aware that in the first period, business users were really relying and hoping that the Commission moves fast. And that is, I think, understandable that they started with public enforcement, with complaints, seeing how far the Commission acts and how far can be achieved through that. I think now, however, it has become apparent that not all cases will and can be solved by the Commission for whatever reasons there are, so that more are turning their eyes to private enforcement. And while we haven't seen many decisions, at least I'm aware of 2 in Germany, and one most recent one at the District Court of Mainz is, I think, particularly relevant and forward-looking. It was an injunction imposed on Google relating to the setup of their operating systems, where it was made dependent more or less on the registration of an email account, a Gmail account, and that was more or less prohibited with an injunction that expands EU-wide. And that was quite a decision in an injunctive relief proceeding, so a fast-track proceeding, and I'm sure we can come back to that later. But there are some first proceedings in this respect, and they do look promising.
Thank you. Yeah, and I mean, I'm quite interested in what drives people to bring such cases. And Helen, could you cast a bit of light on that? Like, why would you go to a national court? You referred already to standalone versus follow-on. What drives the decision making here?
I think there's probably not going to be one single reason, right? But one can definitely be frustration, right? That the Commission is not doing enough to address issues. We know how busy they were, and there were all of the articles about being understaffed and not being able to really stay on top of the huge amount of work that was required to designate that many gatekeepers with that many CPSs, to think about what avenue, right? I mean, the DMA is complex in determining whether you're actually going down the avenue of kind of regulatory dialogue, whether you're actually going to look into the investigation, whether you're going to close it, whether there's insufficient evidence, enough evidence. So all of these sort of things at play. And I think at a certain extent, third parties sitting back and thinking, at what point is my issue going to be addressed? And if it's not addressed, what is the avenue open for me? Now, one of the issues is obviously how much is it going to cost me? So I think where a litigation funder can then step in, and there's definitely a gap, that can be something that then may spur people on to think, is litigation an option? I think the other thing is the speed, right? So we've talked about injunctions, actually getting somebody to stop their behaviour now, whilst people think, is there actually a deeper problem here? And then you could actually have a standalone action where a claimant asks for an injunction. Perhaps then the Commission says, okay, you know what, we will look into this, and maybe at that point you stay proceedings, the Commission carries on. And then at the end of that prospect, it kind of morphs into a kind of follow-on claim to say, look, we spotted there was an issue, time's now gone on, and actually now what we are looking for is damages. So I think there's various parts to that. I would say that the other thing I think that may spur people on, and I think it's actually something that shouldn't spur people on, is this idea that you may be able to use the DMA not only to claim damages for something that falls within the DMA, so that would only be the last couple of years, right? But something that is the same behaviour prior to the DMA, right? In which case what we're actually talking about is a potential competition law infringement, and we're not talking about something that has arisen as a result of non-compliance with the DMA. And so what worries me a bit is that you end up having kind of hybrid claims that on the one hand are talking about DMA non-compliance and then trying to pull that into a period before the DMA came into force to say, and look, by analogy, that means that there must have been an abuse of dominance before the DMA came in. Now, will people try and do that? They may well try to do that, but I think we need to be clear that for the period before the DMA, that really is a standalone action, and you better be prepared to build up your claim on abuse, you know, step by step, because as we know, the DMA is not on the premise that you have assumed dominance, right? People have been made gatekeepers on the basis of very specific tests. And therefore, that means that if you want to build up that kind of wealth of evidence, you need to do it step by step. And you can't simply take an EC non-compliance decision and say, oh, look, and that means that there has been non-compliance for the 10 years before this. I think it would be naive to believe that that is how you would play it.
Yeah. And does that go also a bit more to the heart of what private enforcement really is? Because you're actually in front of a court trying to prove your case, right? You're not in front of a regulator.
Absolutely. And I think the court, you know, in some countries you have specialist courts that maybe at least are starting at level 3 of their understanding. But to suddenly bring these decisions relating to the DMA and then try to get them to understand why it is that there might be a link to something beforehand, I think could be an uphill struggle. And they will ask the question, well, hold on a second, is this competition law? Quite clearly, the DMA specifies it's not. It's a very different beast. And I think that that's the first thing that will then come out in those claims, yeah.
Yeah, yeah. Thomas, I'm sure you have something to say about that, but...
No, I can see these tendencies and incentives myself. Now, coming back to your question, I think at the moment, really, injunction is the big selling point. If you want to have relief quickly, and you need it quickly in many cases, there's not much left apart from private enforcement. And in Germany, for sure, you can get a decision rather quickly, and the courts cannot say, we are not looking at it. They have to decide. They have to decide in a certain period of time that is proportionate, and you will get your decision. And I think this is essential in many situations where companies can't rely on the Commission to do something or not, and maybe assume to do something, but then ultimately end up not pursuing it. And then time goes by, and you know, the business user is dead. And you know, so private enforcement is in some situations the only relief that's out there.
Yeah.
Maybe we don't have to look too far into the recent history to see that things like geopolitical landscape, right, a point where the Commission thinks, hold on, how do we make sure that we enforce these digital cases, and does that lead to problems with our US neighbours, etc. You know, if that kind of trend continues, one could imagine that people say, hold on, if we can't rely on the enforcers to enforce this, maybe there is a case to step in and say, right, well, we'll start doing it ourselves.
Yeah.
We'll see.
And Thomas, you referred to the injunction in the German case applying across the EU, if I correct, right? And is that almost inherent in the DMA and its idea of non-discrimination, that if you are going to ask for an injunction, you know, you almost have to buy one, or sorry, order one to apply EU-wide as a court, because isn't there otherwise a risk that you would be discriminating between users in the country in question and users in other countries for a regulation that's meant to apply across Europe?
This takes it on from an interesting angle. You know, already in competition law, this power of cognition, basically where a court, while it has jurisdiction, may only act within the realm of geographic area of its own territory, so can only impose an order for that member state, or whether it can actually impose an order for the whole of the EU is not that clear.
Yeah.
And it's already very relevant in competition law, but under the DMA, of course, even more so. What helps here is, I think, the objectives of the DMA, having a harmonized law throughout Europe, having a gatekeeper that is a gatekeeper in all member states. That facilitates the notion of one injunction for the entire European Union. Also because such injunction, EU-wide, prevents fragmentation, where in one member state it's prohibited and in the other one it's allowed. And while national courts need to harmonize their decisions with the European Commission, they don't need to harmonize them amongst each other. Conversely, this suggests that a court must somehow have the power to have an order for a pan-European geographic region to be much more effective and prevent that 20 others have to decide the same case.
I suppose this goes also back a little bit to the point we discussed earlier. It also depends a lot on who the claimants are, right? If they are a purely national player, it may be difficult for a court to say, well, to prevent harm against you, claimant, I am now going to impose an injunction for the entire continent. That seems a bit disproportionate.
Well, in these civil law proceedings, it's always kind of inter partes.
Yeah.
So the claim is limited to the interest of the plaintiffs, and if the plaintiff operates EU-wide, then the injunction can be EU-wide. If the plaintiff only operates in one member state, it's difficult to say that the judgment should go any further. So yes, the scope of the business of the plaintiff predetermines how far the order can get.
Yeah, thanks. All right, let's zoom out a little bit, Joe, and just look at the key economics behind these digital platform cases, whether they are before the European Commission or before national courts.
Great. Yeah, thanks very much, Diane, and thanks very much for my exclusive position as an economist here. Before I give a few comments on the economics of these types of cases, I should just give a disclaimer that I worked for Spotify in the context of the music streaming case, and I'm working on a couple of cases against Apple in the EU and UK. So I think thinking about economics in the context of the DMA, I mean, yeah, we economists try not to be paranoid, but I think quite a lot of economists think the DMA was deliberately designed to get rid of us, basically, which, fine, okay, we'll try not to take it personally, but there we go.
Found them out.
And I think clearly, in terms of establishing liability, the DMA provisions just look very different from what you'd have in a standard competition case. You don't need to define the market, you don't need to develop a theory of harm, you don't need to establish the abuse in anything like the same way. It looks actually much more like a tick box exercise. You know, we have these specific things you need to comply with, and did you comply with them or not, basically? And obviously, there's a lot of difficulty in determining the interpretation of the regulations and whether that compliance is sufficient, but nonetheless, the role for economics there is pretty limited. But I think so that's a liability, and that clearly affects public enforcement in particular. But I think on the damages side, it then looks quite different, and particularly if you think about potential follow-on damages cases, which I think we may well start seeing in the, well, maybe coming months, but certainly coming years. Actually, that, I suppose, benefit of the DMA in terms of making things easier at the establishing liability stage then becomes almost a problem for the DMA if you're thinking about follow-on actions and establishing damages, just because there's a lot less material available. And I should say, you know, I've really enjoyed this event, but there haven't been enough numbers for me as an economist, so I'm going to give a few numbers here. I was looking at the Commission's music streaming decision, and also the DMA decision on the anti-steering provisions for the Apple App Store. So covering very similar sets of issues, of course, across the two decisions. Now, in the music streaming decision, that's 250 pages. The DMA decision is 67 pages, so roughly 4 times the scale. There are 515 mentions of market in the music streaming decisions. In the music streaming decision, 36 in the DMA decision, 50 mentions of economic in music streaming decision, just 8 in the anti-steering DMA decision. So really big differences in terms of what's covered between those particular decisions covering very similar topics. So what's missing and why does it matter? Well, I think there's two main things that aren't there in the DMA decisions that you might see in a standard competition decision. First, of course, there isn't that detailed discussion of competitive constraints and the nature of the market, which is really important for determining what the counterfactual is. For instance, is it plausible that in a counterfactual, an app developer would have had other app stores they could go through? Our website purchases, our purchases on a Spotify website, for instance, is that a close substitute for a purchase on an app store or not? That's just not the type of issue that's, of course, covered in a DMA decision, whilst it would be covered in a competition decision. And that means that actually there'll be quite a lot of work, I would argue, for the economist, but quite a lot of work to try to establish that in a private follow-on case. And I think the second area that's missing, of course, is much discussion of effects. Again, to give numbers on this, there's about there are 44 mentions of effects in the music streaming case, and just 2 in the anti-steering decision. And just to give an example of a statement in the music streaming case, where it says, it is likely that the anti-steering provisions have caused direct monetary or non-monetary harm to around 21 million iOS users, around 5% of the EU population, right? So it's a very clear statement of what type of harm has been produced and to who suffered that, which clearly can then be tapped into for a follow-on case. That's just not the case in the private enforcement case. So I think there is, of course, a lot of similarities in terms of fundamental economics that will be applied in private enforcement cases as in public enforcement, but also as in competition cases. But I think there's quite important differences actually between how much work the economists will have to do and how much the claimant parties will have to establish in a DMA context versus a sort of more typical competition case.
Thanks. And I mean, that sounds pretty pessimistic, but
not necessarily for me, of course. But okay.
But Thomas, do you feel that economists have been disintermediated, or?
No. Well, of course, if we are talking about follow-on damages claims, there is always a wish list, and the wish list starts with the decision should be so detailed that you just have to copy-paste it, and then there's your quantum calculation. Now, I wouldn't go so far as to say we should slow down the Commission's work to make sure they produce these documents for follow-on damages claims. That can be achieved through other means. Nonetheless, I think economists still play a major role, because the DMA, there's a lot of behavioral economics at every corner. And if you want to really have a compelling case, and you want to really bring this across, and you also want to think about which remedies work and how they work and when they will not work, you need to embed this in sound economics. And for that, you will still need some experts that explain in private enforcement for injunctions just as much as in damages claims. They explain in simple terms, if this happens, this is the effect. If this does not happen, then you won't see this. So I think it's just a slightly different role that economists will play, but they still have a major role in that setting.
Yeah, and as I was hearing you talk about this, Joe, I did also think about one provision of the DMA in particular that does seem to have a very clear need for economic input, which is where we're talking about friend and what is friend, right? So, I mean, how do you see the role for economics there?
Yeah, it's a very good point, and economists, well, not just economists, but love throwing around the word fairness, but hate defining it. And this is clearly a kind of question that, well, has come up a lot on some of the patent litigation, things like standard essential patents, but is coming through also in the DMA context. I think the thing that, at least so far, I think economics has been able to provide for some of those FRAND discussions is boundaries, right? So I think it's a very difficult thing to be able to say, well, the right rate that should be paid for this pretty difficult intangible good, essentially. You know, might be access to an app store, might be you know, ability to get kind of search data, for instance, from a Google. It's very difficult to be able to say precisely, I think, what that's worth purely as a matter of, okay, economic reasoning, and things like real-world evidence, things like comparables come in very importantly there. But I think what hopefully we have managed to do, or are managing to do, is provide at least some boundaries on what types of deals look like they might be economically justifiable as fair and reasonable. And that's based particularly on, okay, how can we think about what value each of the parties in a transaction is bringing? What value is, for instance, coming back to app stores, what value is Apple bringing to app developers by making it possible for app developers to reach device users? But conversely, of course, what value is the app developer bringing in terms of both enhancing the value of the App Store, potentially also enhancing the value of the Apple platform as a whole, and getting people to buy the phones in the first place. So that's the sort of, I think, analysis that we've managed to, we collectively, I think, have managed to make at least some progress on. But I think there's quite a lot more to do there.
Yeah. And I mean, in IP law, this idea of what is FRAND has ultimately kind of made it to courts, right? Rather than it being an issue for regulators to determine. Could that ever happen here with 612?
Yeah, I don't see why not, and I would expect it will, to be honest. I mean, probably some of my fellow panelists will have other views on this, but yeah, certainly in the UK SEP cases I'm aware of, you know, there's been quite detailed and I think overall pretty rigorous discussion of some of these nitty-gritty questions of how to determine FRAND pricing in those contexts. I don't see why there wouldn't be something similar coming through with the DMA.
Reactions?
It's quite a big ask for courts that are not used to doing this, right? I mean, which is why, to the point that the Commission has the choice to actually put additional information in its decisions to steer people in the right direction. I mean, I think courts will be desperately crying out for that support. And I think that's exactly why Article 39 will come into its own, because at the point where a court starts struggling with these things, they can obviously ask the Commission to step in and give written observations, or even actually orally to come to court and actually explain how they see these things. So I think I would be very wary to say it would be on a national court to make a decision around FRAND. I'm not saying it wouldn't happen. They may well be put in that position, but one can only hope that at that point they kind of say, hold on a second. I mean, they also have the ability to refer the case to Luxembourg, ultimately, if they think that there's something at European level that needs, you know, clarification. But I would think first and foremost, they'll probably be talking to the Commission about it.
Maybe just from a funder's perspective, and without jumping ahead, but basically everything you described about the difficulty establishing a quantum case here, getting your head around the quantum, that is obviously one of the things that are front and center for us as well in making investment decisions in cases. So that was a massive benefit, I think, in classic antitrust cases, follow-on abuse of dominance. Here, it is a critical piece, I think, for us to get a better sense of early on.
Yeah, I think that indeed, I mean, you wanted numbers, you know, like quantification is obviously something that lawyers are not very good at, and where I think there's always going to be a role, Joe, so don't worry too much. So I wanted to turn more a bit to the public policy side of things, and you know, whether we should see, you know, private enforcement there as a solution or rather a problem. Of course, the DMA is at heart a regulatory regime. It has kind of established a system of, you know, regulation on these companies, which is almost a bit like sector regulation. You know, there might be a risk, I guess, that private enforcement at a national court would, you know, run a coach and horses through this whole idea of a regulator who is having discussions and who is slowly but surely coming to the right outcome. Is that a problem, Helen, or?
I think you know my answer to that. Yeah, I think that is a really big problem, potentially. I mean, on the one hand, we have a regulation. It has direct effect. So when this was being put together, people acknowledged that there could be a role for it to be litigated in national courts. But on the other hand, this is not competition law. This is a regulatory tool, and it requires regulatory dialogue. Now, what's a bit strange about this is that there's a real tension between those two, right? Because for something to have direct effect, it needs to be precise, it needs to be unconditional, right? You need to know what the rule is and how you're then going to implement it through litigation in courts. On the other hand, there's regulatory dialogue, which inherently indicates that the Commission is thinking, okay, let's establish a dialogue with the gatekeeper to determine between us exactly where we think this rule is going and where we need to come out with a solution. So almost inherently, by having a regulatory dialogue to actually reach consensus on what the rule means and what the expectation is on the gatekeeper to change their behaviour, you could argue that inherently takes away the certainty that you need for direct effect. So where does that then leave litigation versus what the Commission is doing? And of course, for the gatekeeper, to be actually challenged by a rule in court, whilst at the same time trying to have this very delicate conversation with the Commission to say, okay, we would be willing to do this, but we're not going to be doing that. And in some instances, gatekeepers have been very public about how they see this, but in other instances not. So to be having kind of some private conversations about how do we change our behaviour and in what way, versus, okay, now we're going to have to come out very publicly and indicate this is how we see the rule. So there is a huge tension there. Yeah, absolutely.
Thomas, how do you see that?
I slightly have a different perspective on this. Article 8.1 is pretty clear. The obligation to comply is with the gatekeeper, and the burden to show that is with the gatekeeper. Article 8.3 offers the gatekeeper the possibility to request from the European Commission to engage with them in a dialogue about whether their measures suffice or not. Whether the Commission takes this on or not is up to them. They don't need to have a regulatory dialogue as in the original provision of the directive. Now it's really a discretion. They will do so if they want to specify for a specification decision, but they don't have to in a normal non-compliance situation. So the idea that it's inherent that there is a dialogue behind closed doors and somehow they find a path that suits them without involving the affected third parties is not really what the DMA is now about. And it couldn't be, because it would be a contract to the detriment of third parties that were involved in the debate. And we've seen in the past that sometimes the Commission negotiates or thinks it negotiates with a large player with an outcome that they then present to the public, and they are laughed out of the room because the affected party are saying, what were you thinking? And I think if we really take this issue of regulatory capture seriously, we can't possibly rely on such behind the door, whatever they are, type of negotiations. So there needs to be some control, and courts will have to play a role in this. And therefore, I think the possibility for the gatekeeper to engage with the dialogue under Article 8.3 is nothing that should preclude private enforcement. Obviously, Article 839 was designed with a view to that. The authority, the Commission, can express their views to national courts. They can express their concerns about the way the national court proceeding is going. They may even go so far as to say, look, before you make this decision, let me launch this investigation, and thereby you are kind of stopped. But if they don't, because they have an interest in these national proceedings, also with a view to their own capacity restraints, then why should the national authorities, the national courts, not go forward? So I think Article 39 draws a very nice balance between the interest of harmonized, coherent legal framework towards not stopping national courts from moving fast where the Commission can't do it.
I see that point, Thomas. The only thing is, I think that then it's on the Commission to prove that it's kind of ignoring third parties in that dialogue. Now, there have been some criticism that that has been the case, right, that insufficient people have gone through the door or been sufficiently listened to as part of those discussions. So I totally get that, and I think that, you know, sometimes it's whoever, you know, cries loudest gets the most attention. With the Commissioner, there's other people that perhaps have not had the sufficient attention in that dialogue. But I'm certainly not suggesting that you know, this is a situation where third parties have no option with the regulator, right? They should be going in and speaking to the Commission and saying this is what we see. Whether they're heard or not, I think, is a separate point, and therefore they may be driven to the litigation process. But it's not like the regulatory dialogue excludes them from having those discussions with the Commission.
Joe?
I'll just come in on this with a bit of a personal anecdote. So I was, before I went into private practice, I was chief economist at Ofgem, the British energy regulator, and there was no serious prospect of private enforcement of regulations. And I think we did lots of good things. I hope we made lots of good decisions, helped GB energy consumers, etc., etc. But I definitely think that with hindsight, there were some issues that were pretty important that, from a combination of administrative priorities and maybe just, you know, blind spots, not realizing them, we just didn't pursue at the time. And I think there is a real benefit in having at least a backstop of private enforcement in that kind of context. Now, yeah, equally, I think with Helen that there are legitimate worries that that backstop might become so important it completely kind of overshadows the public enforcement. You do need a balance there. But I would certainly pretty strongly stand up for at least something in that backstop, because, you know, no organisation is going to get this right all the time, and having recourse to courts is a good thing.
Thanks. Jeroen, I think for some people it might be strange to look at litigation as an investment opportunity, but for a litigation funder, this is literally your core business. Can you explain a little bit more, you know, what your role is and how you see it applying specifically with respect to the DMA?
Yeah, absolutely. So, as you say, litigation funding, what we do is essentially commit capital to law firms, to corporates, in the pursuit and to finance the pursuit of litigation claims. That can be an arbitration claim, a standard commercial dispute, antitrust follow-on, whatever. There are a number of ways we can work together. So maybe briefly taking a step back about Burford. Burford was created about 16 or so years ago. We've built over, I think, the last 15, 16 years, a pretty sizable portfolio, committing about $8 billion per overall now in the portfolio, and it's a relatively healthy mix of different types of claims. Maybe to go through the different kind of categories of what we do, you know, the standard building block of a legal finance investment is always kind of a single case investment. We finance the legal fees for the lawyers, the costs of court proceedings through the appeal and first instance process, and in exchange for that, we receive a share of the profits. I mean, that's in a nutshell what we do. So it's always a non-recourse investment, meaning if the case loses, we lose our money, and as a result, we have to conduct very deep due diligence, really get our head around, whether or not a claim is meritorious, how causation looks like, whether, how the economic theory works, the quantum theory, how the financial position of the defendants is, etc. All these types of risks have to be assessed in detail and determined whether or not they're manageable enough and then the case is viable. That's the single case investment. We can do that in multiple cases as well. There are portfolio arrangements with corporates, with law firms. Sometimes if a case is sufficiently matured, meaning there's perhaps a first instance decision, a helpful first or second instance decision even, or an award that is final and binding, we even take equity in the claim occasionally. So we purchase parts or entire awards and enforce them across the world. So there are different ways we commit capital to the legal world essentially. What types of matters do we finance? There's no particular preference here. It's relatively opportunistic as long as, I say, the case is meritorious and we kind of understand all the risks involved. In Europe, and that leads me over to your question, Burford has long been involved in financing follow-on antitrust matters. The trucks cartel is one such case in the Netherlands, in the UK, in Germany. The round timber cartel in Germany is a standalone, partly at least a standalone cartel. We are involved in, again, a public matter. And in all these cases, I think the critical piece is that hardly any of those cases would have even been brought without the capital that we provided. Sometimes, there was a company with like 2 trucks or 1 truck even, sometimes 100 trucks, 500 trucks. And economically, if you look at the cost-benefit ratio, it wouldn't have made sense to bring these cases as one claimant or even as a group claimant. So you had to kind of aggregate them in a way. And the capital that we provide kind of bridges that gap, so to speak. And I would, depending again on the assessment of quantum in the DMA space, I could see, at least in principle, a similar bridge, gap bridging function for legal finance in the DMA space.
Yeah, and I mean from competition law, I suppose people are familiar with the role of litigation funders precisely from the cases that you mentioned, cases like trucks, which feature lots of claimants against a small group of defendants. But in DMA cases, you may also have one-on-one conflicts, particularly around interoperability. And from your experience, for example, in IP, do you consider there's also a role for litigation funders more in these one-on-one type situations?
I mean, potentially, we do have a lot of experience in the patent space. About 20% of our entire portfolio is patent IP related. So it's quite interesting. I think the risk profile is quite similar. They are, I think, high risk investments. The critical piece here for us, and the focus in the DMA, is obviously on injunctive relief and to understand, how will we, in case of success, get our money back? Where are the proceeds? Where's the cash flow? How is that defined? And Joe obviously identified some of the problems determining what exactly a quantum case might look like. If it's injunctive relief, maybe a conversation with a potential client could look like, what are you actually saving if you obtain that injunction? What are your, if you don't receive damages, what's your more revenue, better business growth, some sort of settlement value as part, from an injunction? That could potentially then serve as a collateral for an investment, but it has to be really understood quite well from the get-go. But we see that in the patent space. I remember a few cases we had. I think there was a US main proceedings, and then because Germany also in the patent space is quite popular and well known for injunctive relief. Occasionally you had supporting proceedings in Germany to basically increase pressure on the defendants, and those then resulted in settlements. So those types of dynamics I could see in the DMA context as well.
Yeah. And so, I mean, you've got a new regime here. It applies throughout Europe, including in some, claimant-friendly jurisdictions, let's say. Big defendants, potentially large groups of both consumers and business users who are affected. Do you see this as an opportunity, or is it not as simple as that?
I mean, I think 2 years into the whole thing, we are far away from any kind of gold rush sentiment. So it's not really that. It's very novel, and we do like to see at least some more traction, some more case law. We have not, and not sharing anything secret here, but we were not actively involved in any DMA litigation at this point. We are occasionally being approached with such matters, including the ones Helen just mentioned, where essentially you have a 2-year period under the DMA, and then someone's trying to basically create an Article 102 case on the back of that, with all the challenges you described. So we see some pipeline opportunities coming up, but we do not like to finance legal history in the making. So it's we need a bit more time to look at the space. I think that's our it's watch and learn and wait and see in a way.
Yeah. I mean, Helen I remember when I left the CMA back in 2021, and then I joined a panel organized by Bickel, and you know, there were some people there who were extremely worried about private enforcement, and this was, of course, before the DMA came into force. So it was still about, can we still, you know, add provisions, perhaps limiting private enforcement. There were other people who said, you know, it should actually be facilitated, almost like with the damages directive. I mean, what would you say about this concern about, you know, the DMA opening the floodgates to private enforcement? Has that materialized, or is there a risk that it will still materialize?
I mean, it hasn't materialised, but I think, you know, it could, but I think a lot does depend on, yeah, this sort of steady as she goes kind of, you know, Jorn describes it. I mean, you know, Burford and others are not about to simply put their money into novel cases, right? There needs to be really based on the facts and the likelihood of success. And I think, you know, that inherently will stop the floodgates, because you won't get lots of sort of vexatious litigation, people just bringing these claims kind of for the sake of it without good prospects of success. I think the other interesting thing is, you know, here we are with the DMA consultation, and actually the Commission is not really asking any questions in this area, right? They're looking at AI, they're looking at where the DMA is going. I think had the EC been asked hundreds of times to give their opinion in district courts throughout the EU on DMA litigation, that we would know about it, because the Commission would be saying, oh my goodness, don't we need to think about how we rein this in? That's simply not happening. So I'm aware of a couple of cases, you know, we know a couple of cases in Germany, but yeah, compared to kind of competition cases, pure competition cases, no, I think we're a long way from that at the moment.
Yeah. I mean, Joe, and what do you think is behind that in terms of economic incentives?
Yeah, well, I do think quite a bit of it, as Jorn was suggesting, just comes down to, can you make the economics of a case stack up? And at the moment, it's pretty hard. And part of that is just very mechanically, because you've only got a year of damages or a year and a half of damages, and that's just going to be very hard to build a case on. I do think, you know, looking a bit more broadly, I think almost there's a bit of a catch-22 maybe with some of the prospects for cases in this space, in that, you know, I think Jorn quite reasonably wants, you know, doesn't want to be making legal history, wants a flow of cases to come through before, you know, is prepared to put large amounts of money at stake. But I think that in a way the most likely route or scope for lots of private enforcement will be where companies believe that there's under-enforcement by the EC. So if the EC isn't actually bringing many cases or bringing things forward, then firms will think, hang on, we need to bring a private case. So, but inevitably in that case, there won't be much case law to draw upon. So we'll need somebody who's prepared to take that risk, I think.
Yeah. Yeah, I mean, you mentioned it, Helen. There is, of course, a consultation around whether anything should change, and private enforcement was not part of that consultation in any way, really. So, yeah, to close off and before opening the floor to questions, what do people think on the panel? Should the Commission change anything, or, you know, should there be any more either restriction or facilitation of private enforcement, or should we just look at how things go for a few more years? Have I answered the question already?
Yeah, I think we need a couple more years to see. But then I think if it looks like the balance is out of whack, that I think that then people need to think fairly quickly about where that is going, because when you look at what happened in the competition space, I mean, there are different views on this, but, you know, what's the impact now of follow-on damage claims is that people are not going in for leniency, right? So that, you know, there can always be cause and effect, and I think it's very important that we see how it goes, and does it actually end up having an undesirable consequence somewhere else, and how do we feel about that, right?
I would say the DMA is all about effectiveness, and if we currently see it's not particularly effective, one needs to consider alternatives, and strengthening private enforcement is one of those. There were very strong reasons why we have a damages directive, which is not far enough because it doesn't cover injunctions, but it's a good step in the right direction. And the same reasons apply, maybe even more so, to the DMA. So why should there not be a DMA damages directive akin to the existing one, or expand the existing one to the DMA? I think there are no strong arguments against it. It facilitates private enforcement, makes it easier for all sides, including the courts, and streamlines these proceedings a bit more, overall thereby adding effectiveness to the DMA.
Yeah, because the damages directive is has not just been a tool to ensure that national legislators, facilitate competition enforcement, but it has also been a way for the Court of Justice to weigh in on issues like limitation periods recently, and I guess that's lacking for the DMA. It would have to be done on the basis of the principle of effectiveness or something, right?
Exactly. There are so many areas of gray zone: disclosure, limitation, presumptions. These are key components that always pop up in competition litigation cases, and they will equally pop up in DMA cases. And the damages directive is helping there, and this assistance is also required here. Several aspects: joint and civil liability, who can you actually sue, which court is in charge, passing on arguments. Several components could already be addressed now from the learnings that we have from competition law, and I would assume most of them are applicable here too. It's akin to a 101 scenario, and why wait if you know already these tools help?
Yeah. Jeroen? Sorry.
Yeah, I think not much to add, to be honest. I think it's really, probably give or take another 2 or 3 years. If we then conclude in the Commission as well that there's more needs to be done also on the private enforcement front, I think it's fair and I think right for everyone, including the capital providers, to kind of know where they're at and what's really the desired level of private enforcement politically and what's actually necessary. I think that's how we see it.
Yeah.
Yeah, and just very quickly from me, but I think the interesting question, we're not quite there yet, whether there are significant numbers of follow-on actions. I think you would of course expect, if there are cases where companies are persistently non-complying, you'd expect people to want to bring follow-on damages actions. Is the framework such that it enables that at the moment, or is the information the Commission publishes sufficient to enable that? I think the jury's out on that.
Yeah, because I'm just thinking of this scenario of the hybrid case with a 102 component and a DMA component. It might get quite complicated whether principles from the damages directive, for example, apply to that full case or only to the 102 elements. I suppose it's the latter.
Yeah, that's a good question.
It's the latter, which of course would be a bit odd if you have a clear-cut DMA infringement, but the tools to quantify the damage are stronger for an Article 102 infringement, which may be a weaker case. And all of a sudden, you feel kind of, I need to argue the 102 to take advantage of, for instance, disclosure and so on, limitations in the damages directive. And this just shows that there is a loophole that needs to be closed.
I mean, but of course, when you're arguing a hybrid case, for example, something like statute of limitations, it's inherently going to be the 102 bit.
Yeah.
It's coming up in the argument as to whether you're out of time on that. What one would expect.
Yeah, that's fair. But I think 102 will continue to be a part of private enforcement of these kinds of cases for a long time.
No, I think that's probably right. Yeah.
Okay, well, it's almost time for drinks, but not before we've answered a few questions from the room. So, who's got a question for? Yes.
Yeah. Well, thank you very much for the panel. I think it was really interesting. I mean, I sense a bit of pessimism in the panel, which I don't think is justified. I mean, I would be very bullish about private enforcement with respect to the DMA for several reasons. I think, number one, a fundamental design mistake of the DMA is not to allow national competition authorities or national regulators to enforce it. I mean, I think one of the reasons that was mentioned was uniformity. It's important to build the case law and so on and so forth. But if you look at the way competition law, EU competition law, is implemented by national competition authorities, I don't think you should have that kind of worry. I don't think national competition authorities can do whatever they want. They have to share their draft decisions with the Commission. The Commission can actually take the case if they think it's better for them to take the case. By contrast, involving them would obviously trigger way more enforcement, considering that the Commission doesn't have the means to achieve its ambitions. So I think that the greatest reform that needs to be made with respect to the DMA is not so much with respect to content or whether AI should be included. Yes, it should, but I think more fundamentally, we need to have national regulators involved. As long as they're not involved, it is, in my view, clear that private parties or trade associations will progressively lose patience with enforcement. At the moment, it's still early, and I think there are a number of pending investigations, such as, for example, on the Apple terms or Article 6.5 with respect to Google. If these don't deliver, I'm pretty convinced that they will be private enforcement. Think about one provision of the DMA, Article 6.12, FRAND. If this provision was implemented, the Commission is sleeping on it for all sorts of reasons. It would take me 20 minutes to explain. But if this provision was implemented in court, all App Store issues, or pretty much most App Store issues, will be dealt with in one go, right? On the damage side, I mean, obviously, it's too early. You need decisions. These decisions are issued. You know, we have, how many do we have now? 2, I think. Maybe I'm missing one, but let's say 2 or 3. And if you think that it takes several months to build a case, I mean, obviously, there's no case yet. But I really believe that there will be hybrid cases very quickly, or even pure DMA cases. Of course, they will be tricky, but all cases are tricky. It's always been tricky. These cases are, by definition, complicated. And yet, you know, there are many of them, and the case law progressively deals with all the issues. I just wanted to be a little bit more bullish on this one, and thank you very much again for the panel, which I enjoyed very much.
Reactions?
We love your bullishness.
Ah, yeah.
No, I mean, I take that point completely, and I think you're right. It will happen, and it's all I can say is it's a good job that there's a bunch of really, really bright people in this room to make sure that judges understand the issues on the table, right? Because to your point, Damien, you're right. It was a shame in some ways that national competition authorities did not get any powers under the DMA because they are at least, you know, up to speed in how you deal with digital and competition law cases. But when you look at the differences in level of a court within different member states dealing with these things.
Same for competition.
Yeah, okay, but even more so in many instances. One can only hope that people choose the right forums with the right people and that it's argued, you know, with all these smart people in the room in the right way.
Other questions?
Victor Zimmermann, Deutsche Telekom. I would have a question if the Mainzer case gave us a glimpse of what DMA enforcement in the future will be like or the way forward, considering 2 aspects. One, in general, the hesitance from the Commission regarding the political environment and everything to effectively enforce. And now we have like a case where we have a positive injunction, but also on the other hand, that going forward as in main action compared to in interim relief, which was the first stage of the proceeding, wasn't effective, given the high requirements we have for giving a performance order. And this will probably most of the times be the case in DMA compliance where we need engineering efforts to stop the infringement. So what would be your stake on this?
Yeah, firstly, I think regarding the geopolitical landscape, I think it's clear that this provides a lot of ammunition for private enforcement because a judge won't be impacted by that. They will decide, and they will decide on the basis of the law and not some strategic considerations. So that's the good news. On the second question, also in competition cases, we always had to be precise, convincing, and technically compelling so that a judge understands what this is about, what is demanded, and what an injunction can look like. So there is a lot of experience from Article 102 cases in designing strong DMA complaints. And yes, the order in Mainz is a first strong such indication that it can work. There are some weaknesses still in the case that could have been overcome, I believe, and may still in the main proceeding. But the starting point that the court looks at it and says, in my view, this is a clear-cut infringement. There was, no argument around it, and therefore I'm bold enough to just impose this injunction. I think that's the big good news. And if other courts realize there's nothing wrong with complying and with imposing injunctions that make sure they do comply, then we see good progress and the DMA can finally show the teeth it has.
Yeah, we recently also saw a case in the Netherlands under the DSA against Meta, where again the court was comfortable to say there is a clear infringement here. I think that was those were interim proceedings, right? Kortgeding, or was it?
Yeah, I think that.
I think so.
Right.
Yeah. So we'll have to still see whether that stands up in the longer run. Constantina, you had a question.
A quick point and a question. The quick point on the specification proceedings and whether the DMA is unconditional. I think that we need to make a distinction between cases where there is a requirement to adopt implementing measures and a case where there is an option to adopt implementing measures. So just to give you an example, the Media Freedom Act says that member states must adopt rules to make sure that media mergers are assessed by reference to media pluralism. So clearly here you have a requirement, it's not sufficiently precise, it's conditional on the adoption of national measures by member states. I think I agree with Thomas, not just because he's my colleague, I think I agree with Thomas on this point that it's an option in the DMA, it's not a requirement. So I don't think that this will affect private enforcement, to be honest with you. And just a quick point / question for Joe, just to tease him a little bit. Wait a minute, Joe, I've had to become a regulatory lawyer. I've had to reinvent myself as many other people in this room, right? So I was thinking of the DMA and all of the obligations that concern the design of the user interface, okay, the anti-circumvention obligation, choice screens. Shouldn't economists reinvent themselves and become, from competition economists, behavioral economists?
So I think it's a good point about the need to have more behavioral economics, I think, in how the DMA is enforced and how we think about the impacts of all of these dark patterns or similar, the things that to some extent the gatekeepers are trying to do to maintain a position even when there might be things like choice screens available. I think I completely agree with that. Having moved from being a regulatory economist to being a competition economist, maybe I should just jump all the way back, I don't know.
Okay, Jeremy, you have the...
Just a quick point, since Damien is asking us to be bullish about private enforcement, and I think to agree and underline the point that Thomas made, I think there are probably several questions that will surface in the DMA that are not that complicated, and I think that was probably the case in the case you mentioned, which seemed to be about the requirement to have a Gmail address in order to log into Android or something. And that's not very complicated. And I had another example given by one of our guests today. I hope he'll forgive me for talking about it. But the example was roughly about if you're on an alternative app store and you try to download an app on Android, then suddenly it directs you to Google Play.
right? Which is, another one of those tricks that makes the effectiveness of the DMA complicated. Now, if those things really happen, I think it doesn't take a PhD or, a degree in IT in order for a judge to say, this is just wrong, right? So I think there are reasons to think that it's not going to be that complicated.
Last question, I think.
Hi, I'm Shubhanyu Ojla from Dubrau. I had a follow-up point on Article 8 I'm still obsessed about that because I know there is a discretion there, but the fact is that the Commission has exercised that discretion in 2 or 3 instances and has opened those specification proceedings, which goes to indicate that in those cases the Commission was not sure up front and they wanted to sit down with the gatekeeper, come up on a consensus on what compliance is. And indeed, as an EU regulation, the DMA has direct applicability like any other one, but it's quick to just across the board say that each and every provision has direct effect. I think that some of it is a factual question for the court, whether it thinks it's sufficiently clear and precise. So if you want to be bullish about private enforcement, I think the first stage is to determine whether everything has direct effect to go to court.
Well, luckily, we don't have to do that. We only have to prove that whatever provision we are relying on in the case has direct effect. I don't think it would make a lot of sense to try and bring a case where specification discussions are ongoing and leading up to a specification decision. I think you do risk as a plaintiff in a case like that to upset the regulator who's trying to fight your corner. So I'm not sure strategically that's the best thing to do. Other views? Everybody ready for drinks? All right. Well, thank you all very much.
Yeah, we're all ready for drinks.